Dash 1, restore and increase of the democratic weight of French linguistic minority communities. Donc le mot of.
So we have the word of. In the text of the English amendment, the word of should have been taken out, which would make the amendment read as follows.
Demographic weight of French linguistic minority communities. Est-ce qu'il y a un consentement?
Do we have unanimous consent to correct this typo? Unanimous consent? All right. It is done. We will resume where we left off. BQ 38. BQ 38. Oh, it was not yet moved. Okay, it has been withdrawn. This brings us to CPC 32. Over to you, Mr. Godin. Actually, Chair, in CPC 32, I'm returning to the concept of estimates. I think that wording must be corrected. In fact, I believe that we need to paint as accurate a portrait as possible. So my amendment reads as follows, that Bill C-13 in Clause 21 be amended by replacing lines 31 and 32 on page 13 with the following. The Minister of Foreign Affairs shall take the measures necessary for the So it replaces that he deems necessary. We would instead be saying that are necessary. If we really want to show our willingness to make the bill stronger and more effective, then we need to make the wording stronger and more effective. All right. Now, if CPC 13 is passed, a line conflict would preclude Lib 20.1. Any questions or comments on CPC 32? Nothing on the screen, nothing in the room. I'll call the vote.
Monsieur Drouin.
Contre.
Monsieur Iacono.
Contre.
Madame Kayabaga. Madame Natanzio.
Contre.
Monsieur Godin.
Pour.
Monsieur Gould.
Pour.
Monsieur Généreux.
Pour.
Monsieur Lehoux.
Pour.
Monsieur Beaulieu.
Pour.
Et Madame Ashton.
Contre.
Donc 6 contre, 5.
6 nays, 5 yeas, amendment defeated. This brings us to Lib 20.1. Mr. Saray, over to you. Along that same vein, I'm going to read the amendment as I propose it. So this is Lib 20.1, that Bill C-13 in Clause 21 be amended by replacing lines 31 to 33 on page 13 with the following. 2. The Minister of Foreign Affairs shall implement the commitment under subsection 1. And you should have a copy before you. Mr. Godin. Chair, I believe, it's a step in the right direction. We are in the process of modernizing the Official Languages Act. And I think my amendment would have been better because looking at point 1, I'm going to read it for anyone listening to us, either in the room or on Parleview. Point 1 reads, the federal government commits to promoting the use of French and English as it conducts its external affairs and to promote French as part of Canada's diplomacy. I am disappointed. It's better than it was before, but it's weaker than what I was proposing. So I would say I am disappointed, but I can live with it. This is part of parliamentary wrangling, Any other questions in the screen, virtually, in person? No one is raising their hand. So, Madam Clerk, please call the vote.
Pour.
Monsieur Godin,
Je vais être bon joueur, Madame la greffière, je vais voter pour.
I'm a team player. I'll vote for.
Monsieur Généreux,
Pour?
Monsieur Lehoux,
Pour.
Monsieur Beaulieu
Pour.
et Madame Ashton.
Pour.
Eh bien, à l'unanimité.
All right, it passes unanimously. This brings us to... Sorry. You withdraw BQ 39? Okay, BQ 39 is withdrawn. BQ 39.1, Mr. Beaulieu. 39.1 from my party would focus on the Translation Bureau. We would amend the bill by adding, after line 13 on page 14, the following. 42.21. The Government of Canada is committed to ensuring that within 1 year after the section comes into force, A, the translation interpretation, sign language interpretation, and terminology services that the Translation Bureau provides to federal institutions under the Translation Bureau Act are hereafter provided free of charge. B, the duties and functions set out in subsections 4.1 and 4.2 of the Translation Bureau Act are carried out. And C, that the Translation Bureau is given the mandate to use the Government of Canada's purchasing power to develop the Canadian language sector. 2, the Minister of Canadian Heritage, the Minister of Public Works and Government Services, and the Translation Bureau shall take such measures that they consider appropriate for the implementation of the commitments under subsection 1. Right now, as you may know, the government is breaching its own Translation Bureau Act. The Translation Bureau Act says that services shall be offered free of charge. Since they are requiring payment, departments and institutions are having to pay, and some of them have stopped translating their documents altogether. Others are using machine translation or unqualified workers. Some institutions are paying for translation services that are more expensive than what can be offered by the Bureau. So under this amendment, things would actually get less expensive. Prices would go down. Translation would be guaranteed. Both languages would be respected. Parliament would function bilingually, and French language translations would be accessible. I think that's all important, and that is why I have moved this proposal. Unfortunately, BQ 39.1 deals with the Translation Bureau, and it might even require the Translation Bureau to use the federal government's purchasing power to develop the Canadian translation sector. Per House of Commons procedure and practice, an amendment cannot trample on the Crown's prerogative over financial affairs. And amendments cannot draw on funds from the Treasury. This amendment would enlarge the Translation Bureau's mandate, and it would step over the line into the prerogative of the Crown to spend public funds. I deem this amendment irreceivable.
Mr. Godin, Mr. Chair, I would like to present a sub-amendment to this amendment by using exactly the same wording and withdrawing Section C. Just a moment, please.
Merci.
Thank you, Mr. Godin. We have good advisors here. and that's a good thing. Since we've already deemed that the motion is irreceivable, so we cannot amend it, you can contest the decision by the chair, as I'm a good player. Well, Mr. Chair, I would like to consult you. If I table a new amendment on the floor and I just withdraw Part C, is that receivable? Yes, I believe you could do that. Just a moment, please.
Effectivement.
Yes. So we'll wrap up with this. And first I need to turn to Mr. Beaulieu, who may decide to contest the decision by the chair. No, we'll come back with it. We'll yes or no, because then we'll move on to something else. Thank you very much. Mr. Gaudin. So, Mr. Chair, out of solidarity for the translation services, I think in terms of government, if we want to preach by practice what we preach, we need to give them the means to offer translation and to allow all departments to have access to it. And when we say for free, it's not that it's volunteer work, it's that the government will create a general envelope that will take on these costs and will not bill the departments for translation. So what is important to understand in this is that there are departments with very tight budgets, and it forces them to make decisions. And often, unfortunately, what they cut are translation services. So French is not interpreted. And so I think that is important. So, Mr. Chair, I would like to table an amendment on the floor. I don't have the wording in front of me, but I would just withdraw Part C. That is my amendment. I don't know what you would call this, CPC. Well, I'll leave it to our legal expert. I'm sorry, Mr. Chair. I just want to understand what is it's an amendment that he's proposing? One moment, please. What Mr. Gaudin says is that what was BQ 39.1 was declared inadmissible, so he would table the same except minus Part C, so everything but C, which would be withdrawn. So we can make photocopies and distribute it without C. Well, we have it in front of us. Well, Mr. Chair, they're asking for a copy, inaudible for the interpreter. Yes, we will suspend for 2 minutes because it does have an effect on future amendments. We're just suspending.
Yeah.
Let's resume. So there is an amendment. There's no line. Okay, so there is no conflict. The amendment by Mr. Gaudin as proposed is admissible. Inaudible for the interpreter. No, we need to vote first. But it is receivable. Can we give it a name? CPC 32.1. Is that right? One moment, please. Let's call it CPC 32.1. So it is for those of you who are looking at BQ 39.1, it's the exact same wording except for with C withdrawn. So, Mr. Gaudin, are there any questions? Well, Mr. Chair, I don't think that I need to make a lot of comments. I gave my presentation, and I hope that that the government will be open to it. Any questions around the table or online? I don't see any raised hands. Oh, I'm sorry. I think that would really help resolve these issues. It would not be more costly to the government. I think, on the contrary, it would normalize things, and it would be a motor for the language sector. Mr. Gaudin, quickly, Mr. Chair, in terms of cost, I think that everything has a cost, but I think that translators and interpreters are paying us huge service, and these are minimum investments to offer both official languages within departments. Thank you. Any other comments? I see no raised hands. Madam Clerk, let's go.
Contre.
Monsieur Drouin.
Contre.
Monsieur Iacono.
Contre.
Madame Kayabaga. Madame Natandio.
Contre.
Monsieur Godin.
Pour.
Monsieur Gourde. Monsieur Généreux.
Pour.
Monsieur Lehoux.
Pour.
Monsieur Beaulieu. Madame Ashton. Oups, désolé, j'ai pas entendu.
On n'a pas entendu, Mme Ashton.
We didn't hear you, Ms. Ashton.
Ah, j'ai vu un contre.
Montrez le pouce parce que on a vu votre bouche, mais c'est.
Can you give us a thumbs up or a thumbs down? Thank you. We didn't hear anything. So 6 against, 5 for, rejected. That brings us to this is adopted. I voted against because the positive measures have a major impact in Quebec. Mr. Chair, point of order. I'm listening to you. I think that we're disappointed when the Liberals are voted against our amendments. So the Liberals need to respect our view when we don't vote with them. Is this adopted as amended? Inaudible for the interpreter. So the motion is passed. Mr. Gaudin, Mr. Chair, CPC 33 proposes once again. We are insisting on the fact that the text of the bill needs to be clarified, that Bill C-13 in Clause 22 be amended by replacing line 14 on page 14 with the following. The portion of subsection 43(1) of the Act before paragraph 1 is replaced by the following. The Minister of Canadian Heritage shall take the measures necessary to advance the equality of status and use of English and French in Canadian society, and without restricting the generality of the foregoing, may take measures to paragraphs 43(1)(b) to (g) of the Act are. Well, there you have it, Mr. Chair. I think that we are all able to interpret what CPC 33 is seeking to do. Thank you, Mr. Gaudin. So we are studying 22. Mr. Drouin. Thank you, Mr. Chair. And I would like to present an amendment, a sub-amendment rather, to the amendment by my colleague. And if you can stay with me, I will read it into the record that this be amended by substitution in the passage. Take the measures necessary to advance the progression towards equality of status and use of English and French in Canadian society and, without restricting the generality of the foregoing, may encourage the moving towards the equality of status and use in English and French, notably by, and that's the amendment, and in English. So it will be more complicated in English, that the amendment in principle replaces at section 43(1)
to advance with the following, in advancing. Donc, l'amendement.
So the amendment as amended would read as follows. The Minister of Canadian Heritage shall encourage to advance the equality of status and use of English and French by taking all measures. Could you please circulate the sub-amendment? Okay. Did everyone receive the sub-amendment to CPC 33?
OK, on est en train de circuler là, pour ceux qui l'ont.
All right, it's going around. We are distributing the document. This is the amendment to CPC 33 as moved by Mr. Drouin.
Oui, on suspend pendant que le.
Is now received. Go ahead. I have a question for Mr. Newman. Looking at the differences between the amendment I proposed and the sub-amendment proposed by my colleague, Mr. Drouin, what would be the impact of taking out shall take the measures necessary to advance and adding in advancing. What would be the difference? And what would be the impact on how the law is interpreted?
Merci de votre question.
Thank you for that question. In French, note that the present tense has an imperative sense. So when we use the present tense with the verb favoriser, we create an imperative sense. In English, this is created via the word shall. Shall implies a certain obligation. So when I look at the amendment as sub-amended, the general idea is to ensure that the minister advance the equality of status and use of French and English. That is the principle that underlies subsection 16.3 of the Charter of Rights and Freedoms, which would move towards the equality of status and use of French and English. This amendment would also note that certain measures could be taken. That's why I read the text, especially in French.
To capture it in English, the Minister of Canadian Heritage shall, in advancing, am I reading this right? In advancing the equality of status and use of English and French in Canadian society, and without restricting the generality of the foregoing, may take measures. Donc, il me semble ça arrive au même.
It seems to me to accomplish the same thing. This takes for granted that the minister will promote or will advance in English that the equality of use. And as the minister does so, he or she could resort to a series of measures. Thank you, Mr. Newman. Mr. Godin. All right, Chair, what I'm getting is my amendment has been sub-amended, and yet this sub-amendment does the exact same thing as the amendment. That's what I understand following Mr. Newman's comments. So what's the point of wasting time by sub-amending this amendment? That's my question for all of you. Well, I might like to clarify something. I would ask Ms. Boyer what necessary measures means. Thank you for that question. This is an issue that has come up a number of times in committee. When we say measures, referring to necessary measures, there's a question of what proves the measures are necessary. Is it just what the department deems necessary? The word necessary could create an additional burden of proof, and this could actually convince certain departments to not put in place positive measures because they would then have to go and prove those measures are necessary. That's why C13 uses language meaning deems necessary. This would actually move them into action. Requiring something to be necessary would create a burden of proof. Ms. Boyer's answer is saying that some departments might be persuaded to not put in place positive measures. But that's the thing. Departments do need to put in place positive measures, significant ones. That is why we have called for Bill C-13 and the Official Languages Act to be placed under the leadership of one department, and we want that to be the Treasury Board. I get that that horse has left the stable already. I'm not going to tear up my hair over this, but I'm just noting that the bill needs to be amended to be as effective as possible. We know that the Liberals will vote down my version and the NDP will vote with them, so that's it. Hey, you don't have a crystal ball, Mr. Godin. Please respect committee procedure. Excuse me, I have the floor. Would anyone else like to comment on the sub-amendment of Mr. Drouin? Anyone on Zoom? Anyone here in the room? I see no raised hands. Let's proceed to a vote.
Pour le sous-amendement.
Monsieur Drouin,
Pour.
Monsieur Iacono,
Pour.
Madame Kayabaga, Madame Latanzio,
Pour.
Monsieur Godin,
Contre.
Monsieur Gourde, Monsieur Généreux,
Contre.
Monsieur Lehoux,
Contre.
Monsieur Beaulieu
Contre.
et Madame Ashton.
Pour.
6 pour, 5 contre.
6 yeas, 5 nays. The sub-amendment is deemed adopted. We remove to CPC 33 as amended. We shall proceed to a vote.
Pour.
Monsieur Drouin,
Pour.
Monsieur Iacono,
Pour.
Madame Kayabaga, Madame Latanzio,
Pour.
Monsieur Godin,
Contre.
Monsieur Gourde, Monsieur Généreux,
Contre.
Monsieur Lehoux,
Contre.
Monsieur Beaulieu et Madame Ashton.
Pour.
Donc, 7
So 7 yeas, 4 nays. CPC 33 as amended, rather as sub-amended, carries. This brings us to... Just want to make sure that I'm using the most recent version of the amendment bundle. We are now on BQ 39.2. And I'm going to cite the reference number. It's 122 91732. Mr. Beaulieu, would you like to move that amendment? Now, if BQ 39.2 carries, BQ 40 cannot be moved due to a line conflict. I'd like to move my amendment now. BQ 39.2 will not be binding, but it will be important. When we talk about providing funding to certain organizations, we are adding the word transparently. Because, you know, for some time, we have been unable to get all the information necessary. We are unable to get all details concerning organizations who are party to a government agreement. The FCFA, for example, has said that if we receive funds to go about a court challenge, this could cause issues. I believe that we need to be as transparent as possible. So point B is all about the court challenges program. We know that this can be harmful in Quebec and in certain other provinces. So here we refer to quasi-constitutional official languages rights, including the right to ensure provincial and territorial language regimes are respected. What I've heard is that in some parts of New Brunswick, certain regions are bilingual, but they still do not meet the where numbers warrant aspect of the Official Languages Act, which can harm the rights of francophones. It's important to take into account the linguistic regimes set up by the various provinces and territories. We are now adding C.1. Provide this funding as transparently as possible, including by requiring that, after a test case is brought, the name of the funding recipients of the program referred to in paragraph C and the nature of the case be disclosed in the annual report of the independent organization unless there are reasonable grounds to believe that the disclosure would cause harm to the recipients. This is not a binding measure, but it would create an expectation that the government act as transparently as humanly possible. Because we're talking about taxpayer funds here, there should be accountability measures. And C.1 in this amendment was actually the recommendation of a committee that has already carried out a study on the topic, the House of Commons Standing Committee on Justice and Human Rights. I believe Mr. Housefather, who is here in the room with us, actually chaired that committee. So there should be a court challenges program, and there should be a certain measure of transparency. Mr. Joanne. This is a very important issue for me. But very frankly, based on my own experience, I believe ensuring that people have the resources to challenge governments is very important, especially to official language minority communities. If it weren't for the court challenges program, I would not have had access to French language services in Montfort Hospital, where my child was born. I know that Quebec has a different context, but in my community, the court challenges program is essential. What my colleague says is very important. I'd like to hear from Mr. Newman, perhaps. Would this amendment really undermine the court challenges program? Sorry, just for my own understanding, what is your question exactly? Well, my colleague talked about his experience with the birth of his son. Would the block amendment create such a change things in reality? Would it cause the sort of disastrous things that my Liberal colleague just spoke of? Listen, I understand what you're saying, but I do not want to lose myself in hypothetical scenarios. Your colleague has just spoken about his own experiences. And I have nothing else to add. Mr. Beaulieu. So what is being said is, I know about the Montfort case. We were supportive of it in the bloc. But what this says is that after a case is heard, let me find the wording. So this would be after the introduction. Mr. Drouin seems to think that that the introduction would take place before the test case. And we are talking about a situation where there are reasonable grounds to believe that some people would be harmed. Certain groups have come to me, like the FCFA, saying that some details should be divulged after the case is heard at any rate. After all, public money is at play here. Members should actually want to know where public funds are being channeled to. That's part of transparency. I think Mr. Newman wants to add something. Since we're talking about personal experiences here, I was involved in the Montfort case before the Appeal Court of Ontario. I am very much aware of the issues your colleague is talking about. We certainly do not want to place limits on ensuring the rights of Francophone minority communities. The same can be said for the Anglophone minority community, but this is a personal comment I'm just getting out there. Thank you, Mr. Godin. Thank you, Mr. Newman. Mr. Godin. Chair, I'm going to defer to our experts. What my colleague has said on the Liberal side is very important. Throughout Canada, we need to ensure the protection of rights. What I don't see is how this amendment would violate the rights of OLMCs. Could I ask our experts to describe a scenario where the unfortunate hypothetical described by Mr. Drouin would become a reality? Thank you for that question. The issue is that this would involve funding to an independent group, and I'll pause there, an independent group in charge of administering a program. Canadian Heritage is involved in funding practices. We have chosen an independent group, the University of Ottawa, and we declare the amount of funds that are given to the university. After that, when the university disperses the funds, it's their prerogative. This, it seems, would force them to declare their own spending. Mr. Serre, followed by Mr. Beaulieu. Thank you, Chair. I have another question for Ms. Boyer from Canadian Heritage. The Core Challenges program has two parts to it. Could you talk a little bit more about the human rights side of that program? I'm wondering if that part of the program would be influenced by the amendment. Just 1 second. I'm going to pass the mic to Mr. Marcel Fallu. So right now in C13, there's another section, Clause 52, which would amend the Canadian Heritage Act to create something equivalent. As for the human rights side of the Core Challenges program, in C13, the two parts of the program are not dealt with the same clause.
On ne jugeait pas approprié de mettre des choses en lien avec les droits le volet droits de la personne.
I don't want to mix up human rights with the Official Languages Act, but there is a program that is administered by a contribution agreement with the University of Ottawa, which is an independent third party, but it's a Canadian Heritage program. Mr. Beaulieu, and then Mr. Housefather. Well, essentially what we're saying, this clause of C13 states that the minister can provide funding to an independent body, but it specified what it should be used for before the courts, the importance of the case and so forth. So I think that the arguments here would be valid if we wanted to disclose this before subsidy was granted. What we're saying after the challenge happens, if there is no prejudice to many beneficiaries, we would disclose typical cases and so on. So essentially, I think that we should at least disclose the content, disclose the nature of the case at least, so that we can figure out what the money is used for, in what case, in what sector. Otherwise, it's quite obscure. Thank you, Mr. Beaulieu. Mr. Housefather. Thank you, Mr. Chairman. This was a question for Ms. Boyer, please. Now, in line 27,
Past cases of national significance to be brought before the courts to clarify and assert constitutional and quasi-constitutional official language rights. What Mr. Beaulieu is proposing is to say, and quasi-constitutional official language rights, including the right to ensure the existence of a majority French society in Quebec where the future of French is assured. Number one, by taking one element of constitutional
Un
rights.
instant, M. Assefalu, juste un instant. Non, un instant,
Oh,
vous n'avez pas la bonne version.
Excusez-moi, j'en ai dans le paquet. Excusez-moi, M. Beaulieu.
C'est
Est-ce
un
que
nouvel.
c'est plus là? Oh, OK. Ben, je m'excuse.
I'm so sorry. I'd like to know whether, no, Mr. Housefather, we're giving you the new version, which is very recent. BQ 39.2.
Then my question would be different. So now the wording is, and quasi-constitutional official language rights while taking into account the rights granted under provincial and territorial language regimes. If you're going to do that, as opposed to looking at constitutional and quasi-constitutional rights, and you have to look at the rights or the lack of the rights granted under language regimes, let's give an example of Quebec, would this not reduce the ability of the court challenges program to deal with constitutional and quasi-constitutional rights that the English-speaking minority in Quebec would bring forward? Madame Poirier?
I'll pass it to my colleague,
Okay,
Laura
sure.
Newman.
Mr. Newman?
I mean, I see your concern because what it does is it puts a focus what rights may exist already under the various language regimes and schemes that are out there province by province. And so if you're held to that, there may be an argument that, well, you should interpret that in a way that says we're not going to entertain cases that are imaginative in this regard because we've already got this regime in place and we should take that into account. It seems to be a limitation.
Et si ce serait une limite aussi pour les communautés francophones?
It would be for francophones outside Quebec too, because we'd have to take into consideration. Yes, absolutely. When we look at this in the context, Mr. Drouin, just a few comments on the arguments that my Bloc colleague has put forward. The problem is not what happened. It's a tool for institutions, federal or provincial, to find out who got money, how much they spent potentially on a case, and it's an access to justice matter. It's to give them a tool. If you want to cut a hospital somewhere, let's say, how much would it cost for Mr. Kaza and all the lawyers who appeared before the court, the group that represented Montfort, for instance? We'd be in a position to deploy measures, and we know that. Access to justice is important. But the strategy of the lawyers would be, well, we could drag this out in court and use up all the money of the parties before the court. And that's where I have an issue, be it before or after. We're giving tools to other governments to violate certain rights in the future. To my mind, this is a matter of access to justice and the means that have been used to access justice. And to my mind, yes, we give an overall envelope to the University of Ottawa, but finding out who got what, that's why we created a third party in principle. That's why I have some concerns here. Thank you, Mr. Drouin. Mr. Godin. Well, Mr. Chairman, my reading of the amendment proposed by my colleague is the right to information, the right to transparency. Yes, there's a right to justice, but transparency must be communicated. I think that knowing that an organization X, after all this process, got financial assistance, it's perfectly legitimate to find that out. If we look at the amendment under C.1, it is identified the nature of this should be disclosed, except if there are reasonable grounds to believe. What you advanced, Mr. Godin, was reasonable. This could affect the beneficiary. That's protection. Transparency, yes, but without having affecting the rights of these organizations. To be transparent, that information has to be available, and I think that's legitimate because these are public funds. Mr. Beaulieu. The exercise of democracy depends on access to information. If we don't have the most complete and objective information possible, we can't have an enlightened choice. That's fundamental for the exercise of democracy. And perhaps for people in Quebec who are listening, the Court Challenges program was put in place in 1978, immediately after the Quebec Language Charter was enshrined. A lot of people feel that the federal government gave itself legal means with pressure groups. We forget that Quebec is a minority in Canada. We see programs imposed to subsidize groups that will challenge, together with the federal government, the democratic choices made by Quebec. They managed in that way to weaken just about all the clauses of Bill 101. So we have a decline of French in Quebec now, which is more and more pronounced, and we have to solve that. Otherwise, the whole Francophone nature of Quebec, as well as Francophones outside Quebec, is called into question. So a minimum of transparency is the least we could demand. Thank you, Mr. Beaulieu. Mr. Drouin. Just a matter of transparency. When we say Canadian Heritage or any department that got the money, we don't have a breakdown of how much the salaries were per organization. We don't have the operations. We don't have a record of all these organizations. So the argument of transparency doesn't hold water. We know that the university got money to administer the program, but the details, well, you have to go see the university. That's a third party, just like any organization through the government. It's the same thing. You'll get the same answer. It's not specific to Court Challenges. It's the reality for any third-party organization. You don't have a breakdown of the results of every organization. I understand the need for transparency, but we don't have that level of detail. Even if you have an access to information request, you don't get those details. Mr. Beaulieu. These are public funds. This is taxpayers' money. Why did they put this into an independent organization? Well, because at the outset, the people who were parties to the conflict decided who would subsidize them. Even people from the government, Privy Council, sometimes decided. They were the ones pleading and they were the ones deciding to give the money. So there was a conflict of interest that was flagrant. So, okay, we give this to an independent organization, but we should at least know if people can find out in Quebec what proportion of the money was used to invalidate our legislation that we voted on democratically, they could have an enlightened choice when there are elections and so on. That's the basis of democracy. We don't want to stand in the way of anything, and we understood. We reacted in some cases. We try not to harm Francophones outside Quebec, of course, but at the same time, it's important to find out what's going on with our own money. Thank you, Mr. Beaulieu. I don't see any other interventions, neither at the screen nor in person. So, Madam Clerk, I'd ask you to proceed to the vote on BQ, the new BQ 39.2.
Contre.
Monsieur Drouin?
Contre.
Monsieur Iacono?
Contre.
Madame Kayabaga?
Contre.
Madame Latanzio?
Contre.
Monsieur Godin?
Pour.
Monsieur Gourde?
Pour.
Monsieur Généreux?
Pour.
Monsieur Lehoux?
Pour.
Monsieur Beaulieu?
Pour.
Madame Ashton?
Contre.
Donc, 6 contre, 5.
6 against, 5 for. BQ 32 39.2 is defeated. That brings us to BQ 40. Mr. Beaulieu. BQ 40, lines 27, page 14 in English. BQ 40, I'm taking out the first part because we've already voted about that. Okay, just a moment, please. What are you saying exactly? Because at the beginning of BQ 40 involves the Court Challenges Program too.
BQ
39.2 is defeated, so there's no line conflict here. Okay, well, let's leave it there. That's what I'm asking you. So go ahead. Okay, at the outset, what we're saying is this, in order to promote constitutional and quasi-constitutional rights of Francophone minorities in Canada, what we're saying is the Court Challenges Program should apply to Francophones throughout Canada and not be used to demolish language legislation that protects French in Quebec. Under C, it says to encourage provinces and territories to encourage the development of these minorities and give them provincial services, territorial services. We're removing municipal in French and English because in Quebec, Anglophones, from our standpoint, are part of the Canadian majority. That's even the UN's viewpoint. They're not a minority. And in D, it says, well, to help these NGOs and nonprofits, we're substituting on lines 38 to 40 and saying instead opportunities for everyone in Canada to learn French rather than both languages, because we see that it's the French language that should be defended. And under E, it's the same reasoning. Rather than have to encourage union and employer groups, which are under provincial jurisdiction, and nonprofits in providing their services in French, and to foster the recognition and use of that language. Because elsewhere than Quebec, there may be problems with that, but in Quebec, I think that the Anglophone minority is very well respected. And the end is the same thing, implement programs in support of French language minority communities in Canada. Okay, for BQ 40, I have to make a decision here. And Bill C-13 amends the Official Languages Act with new measures to increase the status of French and English in Canadian society. This amendment withdraws English and therefore the English minority. In accordance with page 770 of Usages of the House of Commons, an amendment to a bill is not receivable if it goes beyond the scope of the bill. So the chair feels that this is against the principles of the bill as adopted at second reading in the House of Commons. So I declare this out of order, Mr. Beaulieu. By principle, I contest your decision. Okay, in principle. As a matter of principle. Let's vote, Madam Clerk.
Je vous rappelle.
Let me remind you that the question is will the chair's decision be maintained? That's what you're voting about.
Oui.
Monsieur Drouin.
Oui.
Monsieur Iacono.
Oui.
Madame Kayabaga. Madame Latanzio.
Absolument.
Monsieur Godin.
J'ai une très grande confiance en mon président, alors je vais voter pour.
Monsieur Généreux.
Oui.
Monsieur Lehoux. Monsieur Gourde. Monsieur Beaulieu. Et Madame Ashton.
Oui. Pour.
Merci. Donc, 10.
Thank you. So 10 for, 1 against. So the chair's decision is maintained. Phew. Inaudible. Okay, we're not going to argue about this anymore. It's defeated. So that brings us to CPC 34, page 111, for those who have the package. If CPC 34 was to be adopted, BQ 41 could not be because of a conflict in lines. Mr. Godin, you have the floor. I have 110 here. Is it 121, 43, 420? Yes, but in the new package, it's 111. It arrived just before I sat down. Now, we're having trouble following here, but you have the right reference number. That's what's important, the right reference number and CPC 34. Fine, Mr. Chairman. So, the amendment that we're proposing from the Conservatives, CPC 34, I'll read it, that Bill C-13 in Clause 22 be amended by replacing in line 5 on page 15 with the following. Assure public consultation and full consultation with each of the provincial and territorial governments in the development of policies. So we're adding provincial and territorial governments, Mr. Chairman, because I think it's important to consult those governments, those levels of government, which are very important, and we have to work in cooperation with them. Thank you, Mr. Godin. Questions? No questions? Okay, let's go on to a vote.
Contre.
Monsieur Drouin.
Contre.
Monsieur Iacono.
Contre.
Madame Kayabaga. Madame Latanzio.
Contre.
Monsieur Godin.
Pour.
Monsieur Gourde.
Pour.
Monsieur Généreux.
Pour.
Monsieur Lehoux.
Pour.
Monsieur Beaulieu.
Pour.
Madame Ashton.
Contre.
Donc, 6 contre.
6 against, 5 for. This is struck down. So now we are at BQ 41. Mr. Beaulieu. BQ 41. Consultation and public information. And public consultation and separate consultations with the provincial and territorial governments in the development of policies. And at the very end, we continue the application and review of programs to promote the equality of French and English in Canadian society and inform the public and provincial and territorial governments relating to these policies and programs. So I think that it's important to consult the provincial and the government of Quebec rather than to infringe in provincial jurisdiction. And I think that it does not respect the provinces and the territories. Thank you, Mr. Beaulieu. Comments? Mr. Godin? No. And no one on screen either. So, Madam Clerk?
Monsieur Drouin.
Contre.
Monsieur Iacono.
Contre.
Madame Kayabaga. Madame Latanzio.
Contre.
Monsieur Godin.
Pour.
Monsieur Gourde. Monsieur Généreux.
Pour.
Monsieur Lehoux.
Pour.
Monsieur Beaulieu. Et Madame Ashton.
Contre.
Merci. Donc, 6.
6 fours, 5 against. It is struck down. Now, CPC 35, Mr. Godin. Mr. Chair, CPC 35, I will read it for you. that Bill C-13, that Bill C-13 in Clause 22 be amended by replacing line 6 on page 15 with the following. And review of programs relating to the achievement of. So it's encouraging the bill and moving towards equality. And we say relating to the achievement of. So it was a bit philosophical before, and we're trying to be more pragmatic here in the Conservative Party. So I think that this change makes it clearer and less open to interpretation. Thank you. Comments, questions? No one? I would like the clerk.
Monsieur Godin, pour.
Monsieur Drouin?
Pour.
Monsieur Iacono?
Pour.
Madame Kayabaga?
Pour.
Madame Latanzio?
Pour.
Monsieur Godin?
Pour.
Monsieur Gourde?
Pour.
Monsieur Généreux?
Pour.
Monsieur Lehoux?
Pour.
Monsieur Beaulieu?
Pour.
Madame Ashton?
Pour.
Merci. Donc, à l'unanimité.
Thank you. So CPC 35 is adopted unanimously. BQ 42, Mr. Beaulieu. It says still about consultations. They take the measures deemed necessary for the principles, the review of the moving towards equality of status and use of French and English in Canadian society, taking into account the specific need to protect the French language in Quebec and its status as the only official language in Quebec, and shall provide information to the. I think that if we say that the federal government intends to protect French, I think that needs to appear somewhere in the Act as well. Thank you, Mr. Beaulieu. Questions, comments? No one. So, Madam Clerk, a vote, please.
Contre.
Monsieur Drouin?
Contre.
Monsieur Iacono?
Contre.
Madame Kayabaga?
Contre.
Madame Latanzio?
Contre.
Monsieur Godin?
Contre.
Monsieur Gourde?
Contre.
Monsieur Généreux?
Gratte-moi le dos, ma
Contre.
gratte-tienne.
Monsieur Lehoux?
Contre.
Monsieur Beaulieu?
Pour.
Madame Ashton?
Contre.
Donc,
10 against, 4 fours, which means it's rejected. That brings us to the end of Clause 22. So should it be adopted? A yes, unanimously? Okay, thank you. Thank you to everyone. So we are up to Clause 23. Mr. Godin, CPC 36. Well, Mr. Chair, I will withdraw my amendment, CPC 36. Thank you. Amendment CPC 36 is struck. CPC 37. CPC 37 states that Bill C-13 in Clause 23 be amended by replacing lines 13 to 15 on page 15 with the following. Shall adopt a policy on Francophone immigration whose purpose is to restore and increase the demographic weight of French linguistic minorities communities in Canada in order to enhance their vitality. I think, Mr. Chair, it's as if I were speaking on behalf of the FCFA, and it's an additional tool in the Act to ensure that we can draw attention to this topic. Before asking for questions and comments, if there are any, I would just add that this is CPC 37 is adopted, BQ 33, BQ 43, and LIB 21, the new one, BQ 44, and NDP 10 cannot be moved because of a conflict of lines. I will just repeat the amendments that can be affected. BQ 43, the new LIB 21, BQ 44, and NDP 10 cannot be moved because of a conflict of lines. CPC 37, are there any questions and comments? Yes, Mr. Chair. I will ask the question. let's pass through CPC 37 so that we can also take NDP 10. Are there any questions, comments about this amendment? No one? So I would ask for a vote from Madam Clerk.
Perry,
Contre.
Monsieur Drouin,
Contre.
Monsieur Iacono,
Contre.
Madame Kayabaga, Madame Latanzio,
Contre.
Monsieur Godin,
Pour.
Monsieur Gourde, Monsieur Généreux,
Pour.
Monsieur Lehoux, Monsieur Beaulieu, et Madame Ashton.
Contre.
Donc, 7
7 against, 4 for. This is struck down. The next amendment is BQ 43. Mr. Beaulieu. Yes. So in 44.3, the Minister of Immigration and we add shall adopt a policy on Francophone immigration to reestablish and augment the demographic weight of French-speaking Canadians, including in Quebec, that respects the provisions of the Canada-Quebec Accord relating to immigration and temporary admission of aliens. Thank you. Before taking questions and comments on BQ 43, I would like to highlight that if it is passed, the new Lib 21, BQ 44, and NDP 10 cannot be moved because of a conflict of lines. So questions and comments on BQ 43. No hands raised in person or remotely, so I will ask the clerk for a vote.
Contre.
Monsieur Drouin,
Contre.
Monsieur Iacono,
Contre.
Madame Kayabaga, Madame Latanzio,
Contre.
Monsieur Godin,
Contre.
Monsieur Gourde, Monsieur Généreux,
Contre.
Monsieur Lehoux, Monsieur Beaulieu, Madame Ashton.
Contre.
This
10 against, 3 in favor. This is motion is struck. The new Lib 21. I will quote the reference number. It is 122-62033. Madame Kayabaga. Do you want me to reread it? Yes. Yes, I would like to move new Lib 21, which is as follows. By replacing line 15 on page 15 with the following. Ties in Canada, including by restoring and increasing their demographic weight. B. By deleting at line 17 on page 15 the word and after A, objectives, targets, and indicators. So in English, there's a difference in the English as well. I'm going to read it in English as well.
13 in clause 23 be amended by A, replacing line 15 on page 15 with the following. Ties in Canada, including by restoring and increasing their demographic weight. B, deleting at line 17 on page 15 the word and after A, objectives, targets, and indicators. C, adding after line 17 on page 15 with the following. B, mechanisms for information sharing and reporting. And.
Merci.
Si je peux.
And if I may, Mr. Chair, so the objective of this amendment is to encourage the establishment and growth of the demographic weight of Francophone minority communities, which could be done through respecting the establishment of Francophone migration and increasing the demographic weight. So the decline of French in many Francophone minority communities has had repercussions on these services like daycares, healthcare, and other programs, and other because of a lack of qualified Francophone staff. And we know the FCFA in a report that was submitted in April 2022 to our committee is advancing the argument of the need for effective reporting mechanisms, and it has been shown that IRCC must develop new tools and mechanisms to follow the progress and measurement and the performance of this Francophone immigration strategy. There need to be indicators that are also developed for a federal FPT program to advance Francophone immigration. We are also asking for IRCC to ask for systematic communication of results of Francophone migration, including the achievement of the objective of Francophone migration and the most generous results that could be expected for public report cards and the annual report to Parliament on immigration, as well as meetings and mechanisms to share information with partners and stakeholders. Thank you, Madame Kayabaga. Before taking questions and comments, if there are any, just to draw your attention that if the new Lib 21 is adopted, BQ 44 and NDP 10 cannot be moved because of a conflict of lines. Mr. Beaulieu. That is why I will vote against it, because BQ 44 is another amendment for the government of Quebec, and what it amends, it asks that we respect intergovernmental agreements on immigration. We know that Francophone immigration in Quebec is essential, and with the emphasis accorded by the federal government on temporary permits, there are fewer Francophones in, and that is leading to the decline of French in Quebec. Mr. Godin. Mr. Chair, I think that what my colleague has proposed as an amendment, I'm satisfied because we are strengthening immigration in the bill, so I like the words like, I think these are stronger terms, and I think that it's very clear, and the department will have to act as a result. So the Conservatives of Canada will support the amendment. Mr. Beaulieu. I agree that we need to strengthen the Francophone immigration objectives outside of Quebec, but I don't see why Quebec couldn't be consulted about this, why there could be proposals that say that you need to strengthen Francophone immigration in Quebec. If French is weakening in Quebec, everyone suffers. We know that Francophone immigration outside of Quebec has a high rate of assimilation. So in Quebec, we have more chances of keeping these people as French-speaking. Thank you, Mr. Beaulieu. I think there is another person who wishes to weigh in. There's no one else who wishes to weigh in, so we'll go to a vote.
Monsieur Drouin?
Pour.
Monsieur Iacono?
Pour.
Madame Kayabaga? Madame Latanzio?
Pour.
Monsieur Godin?
Pour.
Monsieur Gould? Monsieur Généreux?
Pour.
Monsieur Lehoux? Monsieur Beaulieu? Et Madame Ashton?
Donc,
2 in favor? No. 10 in favor. And 1 against. I got things in reverse. The new Lib 21 is adopted. Okay, so let's continue with BQ 44. Oh, just a moment, please.
d'accord?
Okay. Sometimes I say things automatically, and I just said that this would be out of order. Okay. So Let's skip that one and NDP 10. And that brings us to CPC 38. Mr. Godin. Mr. Chair, in the same vein of what my colleague presented about immigration, I think that words are important and we need to give ourselves the tools to be even more firm, to have better results, because we know that in the past immigration has been terrible for Francophone immigration, and this government achieved its objective of 4.4%, but in previous years it did not, and there's a catching up that needs to be done, and we need to achieve 20% to maintain demographic weight. So my amendment, and I will read it, is that Bill C-13 in Clause 23 be amended by replacing lines 18 to 20 on page 15 with the following. A statement that the Government of Canada is committed to restoring and increasing the demographic weight of Francophone minorities in Canada. Thank you. Questions, comments? I don't see any hands raised, so we'll move to a vote.
Contre.
Monsieur Drouin.
Contre.
Monsieur Iacono.
Contre.
Madame Kayabaga. Madame Latanzio.
Contre.
Monsieur Godin.
Pour.
Monsieur Gourde. Monsieur Généreux.
Pour.
Monsieur Lehoux. Monsieur Beaulieu. Madame Ashton.
Contre.
6 contre.
6 against, 5 in favor, so this is CBC 38 is struck down. BQ 45. Withdrawn. CPC 40. It's my turn again, Mr. Chair. CPC 40, still in the same theme. I will read it now, that Bill C-13 in Clause 23 be amended by adding, after line 22 on page 15, the following. A statement that the Government of Canada recognizes the importance of Francophone immigration to economic development. So it is added to Part C of this current bill. And I don't think that I need to be repeating what I've been saying around the table for weeks, so I think that people know our opinion on the subject. Questions, comments? None? Okay, so we'll move to a vote.
Excuse. Oui.
Monsieur Drouin.
Pour.
Monsieur Iacono.
Pour.
Madame Kayabaga. Madame Latanzio.
Pour.
Monsieur Godin.
Pour.
Monsieur Gourde.
Pour.
Monsieur Généreux.
Pour.
Monsieur Lehoux.
Pour.
Monsieur Beaulieu. Okay. Madame Ashton.
Pour.
Okay.
Donc, 10 pour, une abstention, CPC 40.
10 yeas, 1 abstained. Motion carries. Where are we at now? CPC 39. CPC 39. Just to make sure we're all on the same page. This is 12102192. Chair, it is with great pride and great pleasure that I move the following amendment. It would follow up on earlier remarks from my colleague, Mr. Sampson. We want to do more to allow school boards and educational facilities to access federal real property So I'm going to read it. That Bill C-13 and Clause 23 be amended by adding after line 22 on page 15 the following. 44.2. Before disposing of federal real property or a federal immovable, the federal institution that manages it shall consult any official language minority school board or commission and any other interested official language minority community organizations that serve the area in which the property or immovable is located with regard to their needs and interests in relation to it. 2. Before selling or leasing the property or immovable in question, the federal institution shall offer interested official language minority communities organizations A, in the case of property or an immovable whose area does not exceed 12 acres, the opportunity to purchase or lease it in whole or in part, or B, in the case of property or an immovable whose area exceeds 12 acres, the opportunity to purchase or lease up to 12 acres. Organizations don't want gifts. They are ready to put money on the table. What they need is access. We've seen the issues going on in BC, and we believe that in Bill C-13, there needs to be clear wording, clear provisions to avoid those kinds of situations repeating themselves. Think of the number of students. There's lots of people who want to learn French. The issue is infrastructure. So we need to let organizations get their hands on infrastructure. Right now, French classrooms are spilling over. We need to do our duty as elected officials. We need to help organizations access federal real estate, federal buildings that are about to be sold off. I think their needs should be prioritized. Questions or comments? Seeing none.
Okay.
All right. Sorry about that. I need to let you know that before we move any further with CPC 39, Mr. Godin, there's no line conflict with the new Lib 20, the infamous. This is on page 104 of the bundle. There is no line conflict because you are in fact creating a new paragraph after existing one. But when we passed Lib 20, we created a measure that is almost exactly the same as this one. So before we get into questions and comments, I just wanted to make you aware of that. We have essentially already done this. Just to say, Mr. Chair, since Lib 20 carried, the bill already has instructions on how federal real estate should be disposed of. It's not exactly the same as what Mr. Godin is saying. And I'm concerned that this slightly different measure would create a conflict. Government would be required to do two things with its real estate at once. Thank you, Mr. Housefather. I hear what you're saying, but I'm going to look at Mr. Juan to... Sorry, I'd like to turn to our experts and ask what the impact of this would be. I would rather have too much in the bill than not enough. Mr. Newman or maybe Mr. Fallu? I would say that this is not necessary. We certainly don't want to create a confusing situation or a situation where two provisions in the same bill are pitted against one another. If this amendment were to carry, what would be the impact on interpretation of the bill? You must understand, we are making decisions with our sights on the long-term future. I'm open to the idea of withdrawing my amendment if it were to create conflicts, but I'm interested in learning what conflicts would even be created. Just going back to Lib 20. Well, it's actually a little bit more robust. It involves consultations. Now, just with the question of leasing, the word lease might create some questions surrounding the intention of the measure. Well, the intention of the measure is to make things more accessible. Fair enough. Your amendment also includes specifics in terms of acres. I don't have enough context to understand the surface area you're referring to, but I just want to point out that it's in there. I suppose in the end yours is actually a little more precise. The measures and consultations would be roughly equivalent. All right, Mr. Genereux. I'm going to ask the same question, but in a different way. We already debated this when Mr. Sampson moved his motion, and we voted in favor. Mr. Sampson's amendment does something roughly similar. Do you believe the measure that we already passed is enough? The goal, of course, is to make federal real estate available to school boards or to prioritize them in a sale process. Is the wording of the current amendment clear enough? Is it adequate? If not, could we perhaps modify this amendment so it would reinforce Mr. Sampson's amendment? Thank you, Chair, for that question. I believe that Lib 20 is already very clear. It can be implemented, and it would ensure that when the federal government is disposing of real estate, certain groups would be consulted. In order. OLMCs, as well as Indigenous people, would be included in that order and given a chance to purchase federal real estate. Everything is very clear. The only thing that could lead to confusion is a second similar amendment, which then gets into issues of surface area. This could lead to confusion. But Lib 20 is very clear and creates the obligation to consult OLMCs. Mr. Housefather. Just another point, colleagues. I don't want to take the floor for too long, but this refers to leasing. Currently, the federal government does not lease. The federal government sells. We offer different groups the chance to buy federal property, but we don't keep it and then lease it out. So this amendment would completely change our real estate policy. Mr. Godin, I'm going to leave my amendment on the table because, in my view, it is stronger than what is already in the bill. Again, the Lib 20 refers to taking into account needs. So it's more of a suggestion. My amendment would create an obligation. I think it's stronger, and that's why I suggest leaving it. Now, when you talk about rentals, Mr. Housefather, perhaps my wording is a little bit off. But just because we don't rent property now doesn't mean we won't begin doing so in the future, so I'm going to leave my amendment on the table. I think it is important for different OLMC organizations to be able to access federal real estate. We will now proceed to a vote. CPC 39.
Contre. Monsieur Iacono.
Contre.
Madame Kayabaga. Madame Latanzio.
Contre.
Monsieur Godin.
Pour.
Monsieur Gould. Monsieur Généreux.
Pour.
Monsieur Lehoux. Monsieur Beaulieu. Madame Ashton.
Contre.
Donc, 6 contre, 5 pour, CPC 39 rejeté.
CPC 39 is defeated. This brings us to BQ 46. Mr. Beaulieu. Withdrawn. BQ 46 is not moved and is withdrawn. Shall Clause 23 carry as amended? Yes. Carried. Clause 24, beginning with BQ 47. Wow, you are really just speeding along, Mr. Beaulieu. BQ 47 is withdrawn. Bringing us to Lib 24. Withdrawn, Mr. Chair. Thank you, Ms. Latanzio. Lib 25. Thank you, Chair. I have already stated all my arguments about why provincial laws should not be included in a federal act. I have already laid out all my arguments. There's not consensus about the notwithstanding clause and so on and so forth. I just have a few questions first for our public servants before we have a vote. Well, just before we go any further, Mr. Housefather, before we go any further with Lib 25, I will note that if this amendment passes, BQ 48 would not be able to be moved due to a line conflict. Mr. Beaulieu, that is BQ 48. I was just saying that if Lib 25 were adopted, BQ 48 would be precluded due to a line conflict. We will now continue with Mr. Housefather. Thank you very much. Just a quick question for maybe Ms. Boyer, Mr. Newman. Here we are talking about recognizing collaboration with provincial and territorial regimes in order to advance towards equality of status for both official languages. But the Constitution is at play here. Virtually all provinces have their own linguistic regimes. Only Quebec's is included in this act, however. I could understand including all the provinces. I could understand including no provinces. Why is only Quebec mentioned? Thank you, Chair, for that question. My colleague has just reminded me that at the end of 45.1, we say the word notamment, including. These are, therefore, examples. It's not meant to be an exhaustive list. As for what the drafters' motivation was, I imagine they were trying to line up the act with the reform document, which recognizes the Quebec Charter of the French language. We could just recognize French as Quebec's official language. We don't have to refer to the Charter of the French language. Here's a second question, and perhaps a more difficult one.
A section that's not only the preamble, we're talking about a section that deals with a very specific provision. It deals with interprovincial agreements, where the federal government is perhaps saying there's a federal service that will be offered by the provinces. And as a result, we are now going to deal with them to negotiate an agreement. And we've had a judgment in British Columbia that was very, very clear as to the importance of ensuring that if it is a federal service, that the minority language community is offered the service in that language, and the federal government has such obligations. Quebec's Charter of the French language today, Bill 96, which is now referred to in this clause in Section B, explicitly states now that in order to receive services in English for government services, you need to have access to English schools. That is not our policy for the federal government. That is not our policy for federal services. We don't pick and choose who gets access to services in English. If you were a member of the minority language community in Quebec, would you not be concerned that mentioning in Section 45 a law that deprives a certain section of the Quebec population that wants to get served in English the right to be served in English, would you not be concerned that that would porte atteinte à vos droits?
Undermine your rights.
To delete the reference to Bill 96. Can I just ask, Madame Boyer, do you think it's a valid concern whether or not it's,
Thank you, Mr. President, for your question. So in this one, I just want to make one small correction that we're talking about collaboration with the provinces and territories and not necessarily about the offering of services. So this is to say that in collaboration with the PTs, provinces and territories, we take into consideration these legislations and other legislations that may not be listed here. Like the policy for services of Ontario. Do you want to add to that, Warren?
Yes, as I'm sure you're aware, there are statutes and there are statutes. There's the French Language Services Act of Ontario, which one could have mentioned or not mentioned, as the case may be. Each province, Alberta and Saskatchewan, both have language acts enacted after the Mercure case. So there's legislation that could be mentioned. The Charter of the French language is a prominent piece of legislation in relation to Quebec. We all know that. But it doesn't. It's neither here nor there. The fact that it's mentioned explicitly. You're right that the other three explicit mentions relate to constitutional provisions, but that's just part of the structure of the text. It does not take away the fact that, as Madame Boyer noted, that the clause ends by saying including, or notamment, and it's all about cooperation with the provinces and territories. It's not about limiting services, certainly not federal services. Those are governed by Part 4 of the Act, not by this outreach part of the Act, Part 7.
Allez-y, monsieur.
Go ahead.
Mr. Newman, the consultation and negotiation of agreements falls under this section of the Act, Section 45, and it talks about may negotiate agreements with the provincial and territorial governments to ensure, to the greatest practical extent, but subject to Part 4, that the provision of federal, blah, 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 is coordinated. So again, you have one act, I'm not aware of any other act in the country, that states who is eligible for services if they are provided in that language, whereas Quebec's Charter of the French language now makes very explicitly who is entitled to receive services in English and who is not. And so, again, my concern is by making and by choosing to make explicit reference when you're not making explicit reference to any other provincial law, even though you're saying that they may be included, you're leading to a situation where I am confident the Quebec government will argue when they are negotiating an agreement for the provision of services to Quebecers that with the federal government, they will say we have to look now at the Charter of the French language that says only this subgroup of people is entitled to get served in English. And again, I express my deep concern about this, as a representative of that community.
Well, I certainly understand your concern as an official. Again, I can only go so far in terms of policy questions, but I would say this: this is concerned with the implementation of Part 7, and also with coordinating the availability of services, both federal, provincial, municipal, but in no way does it limit federal communications and services in English to the English-speaking minority. Those are governed both by Section 20 of the Charter and Part 4 of the Official Languages Act, which is meant to implement Section 20. So I don't see any in any way that federal services from federal institutions would be in any way compromised by the mere mention of the fact that the Charter of the French language, along with other linguistic regimes, are matters that the government recognizes as part of the overall context.
But you're talking about, this is my last one. Again, all my other arguments, again, are still there. This is specific to this, specific where this reference is. But again, you acknowledge that now the Charter of the French language says in order to obtain government services, you need to have access to English schools, subject to some exceptions, such as for healthcare. You have that as the general rule.
But not federal services.
No, but Mr. Newman, for provincial services, you're making reference to the law that says that. And you're talking about negotiating agreements, interprovincial agreements between the federal government and the provincial government, and you're making specific reference to that law. Are you telling me that you don't believe that there's any chance the government of Quebec will come back and make that argument in court one day? I want 100%. You're 100% you're saying they'll never make that argument?
No lawyer will give you 100% on anything.
Right, exactly. Thank you.
But I will give you this, that what this is concerned with is taking into account context. That's all this is about. It's not about whether another government may one day make an argument that may or may not fly before the courts. From our
why
perspective,
give him the argument? Anyways, thank you, Mr.
You're
Newman.
welcome. You're welcome.
Avant que j'aille plus loin.
Before we go further, because there are people with their hands raised, the comment by Mr. Beaulieu, which was about BQ 48, I sent you an amended BQ 48, and there's a substitution in it. So Lib 25 no longer has an impact on BQ 48. So in order, Mr. Gaudin, Madame Latanzio, and Mr. Beaulieu. Thank you, Mr. Chair. Yes. To answer Mr. Housefather's comments, I would like to remind him of the importance of the real situation. Quebec is a Francophone majority province in an ocean of Anglophone North America. So I think that that's important to recognize, and that's maybe why that it stimulated our drafters to write, in particular, the Charter of the French language. The Charter of the French language is setting out the objective of the bill. But now, my question, Mr. Chair, is how can Mr. Housefather tell the National Assembly of Quebec and how can he not include all of provincial legislatures? The Charter of the French language is one thing, but if we want to put the National Assembly of Quebec in it, we would have to add all provincial legislatures that work in the provinces and territories. So I think that the amendment that you are proposing, with all of the due respect, is not necessary, and it is fully legitimate that the Charter of the French language of Quebec be written in Part B of this section. I think we need to recognize the situation. We talk about Manitoba and New Brunswick. So as the officials have told us, it is not exhaustive, but I think that the relevance of writing the National Assembly of Quebec does not have as much strength and does not communicate as clearly the specific context in Quebec. Madame Latanzio. Yes, thank you, Mr. Chair.
Madame Boyer, with regards to the understanding of the clause of 45.1 in terms of this idea of cooperation, I seem to see a contradiction, and I'm going to explain myself. When I see And I read the paragraph, taking into account the diversity of the provincial and territorial, language regimes that contribute to the advancement of the equality of the status and use of English and French in Canadian society. And then I look to the A, B, C, D, and as mentioned, A, C, and D speak to both the constitutional element of the English and French. B only states to the Charter de Quebec language, which makes it only French. Do you not see it as a contradiction in terms of the writing of 45.1, where we're trying to state that there's, the advancement of the equality of the state of both French and English?
Merci, Madame Lattanzio.
Thank you, Madame Lattanzio. Mr. Beaulieu. I didn't hear the answer. I'm sorry, Madame Boyer, go ahead. Or anyone else who can answer my question, Mr. Chair.
I can start off, and I'll see if my colleague Warren Newman wants to add. But I would say thank you for your question and for listening to the answer. No, just kidding. Here, I would say that taking into account the diversity of the provincial and territorial language regimes is really in the context of Article 45 on the consultation and negotiations. We shall take into account the linguistic regimes of the different provinces and territories. It's more contextual in nature, and I think that's what my colleague, Mr. Newman, was referring to earlier. But perhaps, is there more you would like to add?
I think that's pretty well the point. You have to see this provision, 45.1, as an addition to what is already part of Part 5. It's taking into account the fact that in implementing this part of the Act, with all its broad range of outreach, that where there is consultation and negotiation with the provinces and territories and negotiating agreements, that will try and in a practical manner ensure the provision of federal, provincial, municipal education services, maybe through synergy and efficiencies, that we take into account that each province has its particular linguistic regime. I don't think it's meant to do more or less than that. And the mere mention that the Charter of the French language is there and has designated French as the official language of the province's administration, I don't think has any more weight than the fact that we also take into account other aspects. I mean, Quebec is also mentioned in the first clause. English and French are used in the houses of the legislature, in the enactment of legislation before the courts of Quebec. So this is just part of the overall balance that is taken into account.
Mr. Chairman, I have a follow-up question, if you allow me.
Oui, Madame Lattanzio, go ahead.
Yes, Mr. Lattanzio, go ahead.
So, Mr. Newman, thank you for your answer. But I seem to feel that, either to be able to have clarity, we either enumerate all of the linguistic regimes, and therefore it would be a very exhaustive list, or adding the B really does not add much, or doesn't clarify, or doesn't do much to be able to ensure that there would be this cooperation. That's my understanding of your answer. Am I correct?
Thank you. I don't think there's much more I could add. This is a legislative policy choice to mention and highlight the Charter of the French language. Yes, one could be exhaustive. It would be a very long provision if that were the case. But already the opening words, the use of the word including, in our view, is sufficient from a legislative point of view. But the policy is a matter for political actors. Thank you.
All right, Madame Latanzio. Monsieur Beaulieu.
Mr. Beaulieu. I can't believe these people who want to exclude reference to the Charter of the French language. No respect of French. The Charter of the French language protects the only majority French state in North America. And we're not calling into question English services for Anglophones, but if we don't ensure that their French education for newcomers, it will erode our demographic weight. It openly minimizes Francophones. I think it's very important. The Charter of the French language has never called into question services to Anglophones. And I would just like to signal my opposition to that. Mr. Housefather. Mr. Chair, I would just like to respond. I've never personalized this, and I think it's unfortunate that my colleague is trying to make things personal. I fully support the fact that we want to promote both official languages. We want to promote French all across Canada. And I have spent my time at Parliament doing just that. I was one of the two people with Mona Forestier that wanted to work on divorce all across Canada. I made a number of amendments to improve Francophone legislation, and I would not have had any problem before Bill 96 being adopted. But now it's clear that there is a minority of Anglophones in Quebec. And point of order, Mr. Chair. What I'm hearing is that there is a ping-pong game here happening. I don't think it's in the interest of the work that we are doing here in committee, so I think we should go to a vote. Go ahead. Can I finish my comments and then we can move to a vote? We are asking to withdraw the reference, and I have no objection to French being the language of Quebec, but you are making reference to a bill that does not have a consensus in Quebec. And there is a minority that is supposed to be supported by this bill, but it is not. This minority does not support Bill 96. And so there is another way of saying it. There are other ways of saying that French is the official language of Quebec. And in fact, Mr. Newman, just to wrap up, you spoke about the way that Quebec was talked about in Section A, but that is constitutional. That is the equality of both official languages before the courts in Quebec and in the legislatures. That's not a provincial act. And even with Bill 96, I can see that there is harm. Not at all, Mr. Gaudin. I am talking about the amendment, Mr. Gaudin. I think that Bill 96 harms Section 133 because we say that corporations have said that not-for-profits that are incorporated must have a certified translation, and that's before the courts in Quebec today. And I don't think that we can avoid having a spat by using different words, by saying the same thing, that French is the official language of Quebec. So I see no other hands raised, so we'll move to a vote, Madam Clerk.
Monsieur Seri?
Pour l'amendement de M. Housefather.
Monsieur Housefather?
En faveur.
Monsieur Iacono?
En faveur.
C'est en faveur, ça?
Oui, en faveur.
Okay. Madame Kayabaga? Madame Latanzio?
In favor.
Monsieur Godin?
Contre.
Monsieur Gourde?
Contre.
Monsieur Généreux?
Contre.
Monsieur Lehoux?
Contre.
Monsieur Beaulieu?
Contre.
Madame Ashton?
Contre.
Donc, 6
against, 5 in favor, motion rejected. Before adjourning, I would just like to tell you, because we're talking about the hours and where we're at, So we will meet for the next time on Friday, March 31st. There will be no meeting on Friday, the 24th, because of President Biden's visit, and there will not be a meeting on the 28th of March because of the tabling of the budget. So we have 3.5 hours of meeting dedicated to clause-by-clause study, and then there is openness for an afternoon meeting on the 31st, and not that Friday, but the Friday after. And what's that? We can work in the afternoon of the 31st, but before adjourning, yes, Mr. Chair, it would be important to know so that we can plan our travel. Yes. No, I understand, but I would like to strike a balance. It's not in bad faith. Yes, I wanted to send you the last week that we sit. As soon as I have confirmation of the hours and the dates, I will send it to all members. Yes, Mr. General. By adding those hours on the 31st, would we fill the 3.5 hours in question? That we would have a half hour that remained. So if we could work on Friday afternoon that day, we should do it. Understood. No, but seriously. Yes. Okay, perfect. So that being said, the meeting is adjourned.
Thank you.